Welcome everyone to the network's fourth public seminar on safe countries and women's international protection. We've got three excellent and knowledgeable speakers that have joined the panel today. But before I introduce them, I was just hoping to make a couple of comments to introduce the subject. Because basically the concept of safe countries is used by states to deny protection to refugees on the basis that they have or may have protection in another country. Now, we've titled this seminar quite broadly, Safe Countries, but the concept of safe countries could be used to understand safe countries of origin. So the country of origin of the asylum applicant is treated as safe, or what we call safe third countries. So an asylum applicant may claim asylum, and then it is suggested that that person would be transferred or to a third country, which is not the country of origin, neither the host country, for their claim to be examined there. So the concept has long been used by states who consider that refugees do not have an absolute right to choose their country of asylum, and that in itself can be controversial. But what happens in practice is that if a country is designated as safe, that may mean that asylum claims are declared inadmissible without any individual examination of the substance of the claim. And that effectively means that a woman seeking asylum wouldn't have access to the asylum procedure. Alternatively, if, for example, a woman claiming asylum comes from a country that has been designed as a safe country of origin, she may be processed through accelerated procedures with lesser safeguards and potentially lesser judicial oversight. So there are important consequences for women claiming asylum through this concept. In addition, research suggests that states actually apply this very differently, in the sense that there are wide variation amongst states regarding which countries they consider safe and or for which groups of individuals. So in the last, 10 years or so, there's been increasing reliance on safe country concepts by states around the world. This is not a phenomenon that is limited to certain regions of the world. And there's been a lot of analysis by scholars, lawyers, and commentators, and guidance by entities such as UNHCR. But overall, we considered that there was little analysis from a gender perspective. And that gender perspective is much needed because safe country concepts tend to lead to a high risk of unfairness for certain groups of people who need international protection. So, for example, where countries of origin are generally considered safe for the generality of the population, some groups might nevertheless be exposed to ill treatment. We'll hear from Sonia Lenigan, and her recent research on the use of safe country concepts in the UK, for example, noted that single women and trafficked women may be at risk in countries that the UK has designated as safe. Other recent analysis from the European Council on Refugees and Exiles observed that the application of the safe third country concept in the EU was often applied without an individualized assessment and in the absence of safeguards for women and girls. We've also seen that the safe third country agreement between the USA and Canada has led to women who were at risk of gender-based violence being refused protection, because the agreement fails to acknowledge that there's a large disparity in treatment of gender-based violence claims between the two countries, i.e. Canada and the USA. So overall, the risk, of course, and the concern is that fewer women are granted asylum. So the purpose of the panel today is to offer some insights into the implications of the use of safe countries for the international protection of women seeking asylum. Some of the broad questions that our panel will consider is how the notion of safe countries may be detrimental to the international protection of women and girls, what judicial oversight might be necessary, whether certain exceptions for certain groups of persons, such as victims of trafficking, or maybe women as a group, would be adequate and necessary, and also the role of country of origin information, or what we call COI, in the assessment of whether countries are considered safe for women. So today we'll hear from Sonia Lenigan, KAAJAL, RAMJATHAN-KEOGH, and Emily WILBOURN. I'll introduce each speaker in turn, and thank you all three of you for joining us today. We've asked you to speak for 12 minutes today, and what we plan to do is basically hear from each speaker in turn, and then we tend to leave the questions to the end. However, whilst panelists are presenting, feel free to put your questions in the chat, and then we'll get to them at the end. Today we're going to start with KAAJAL. KAAJAL is a South African lawyer and director of the Africa program at the International Commission of Jurists. She has significant experience and expertise in the fields of asylum and refugee protection, migration, citizenship, and statelessness. She will be discussing the use of safe country concepts on the African continent. I'll introduce the other speakers when we get to them. So over to you, KAAJAL.
Thank you. Thank you so much, CHRISTEL. Thank you, Moira. Thank you, Nicola. I'm delighted to be here this afternoon. Migration is a highly charged and contested political issue in most destination states. Control of national borders is seen as an essential aspect of the sovereign state. National political debates on migration or migrants can be a flashpoint for political and social anxieties about security, national identity, social change, and economic uncertainty. These political battles are also manifested in national law, which sets the framework within which migrants' human rights are threatened. One of the expressions of international cooperation among states in the field of refugee protection is the adoption of international agreements that implement the safe third country and the country of first asylum concepts. We see this agreement in place in Europe as part of the Dublin III regulation, as well as between Canada and the United States. Despite the long-standing recognition of international cooperation as a necessary prerequisite for the satisfactory solution to the plight of refugees, its actual implementation remains one of the more complex issues in refugee protection. The lawfulness of international agreements that implement the safe third country or the country of first asylum concepts is presumed on the grounds that protection has already been found or can be found elsewhere. The first safe country principle refers to the practice of refusing entry to asylum seekers who, prior to their arrival in the country where they are seeking asylum, have traveled through another country that may or could have offered them asylum protection. This principle has been advanced by the South African asylum management authorities as a basis to deny asylum seekers who have transited other countries en route to South Africa, even though there is no legal basis to do so. South Africa is currently Africa's migration hub, or the continent's top migration destination, as it hosts a high number of international migrants, and this is for the African continent. South Africa, however, does not host the most refugees in Africa, and the countries hosting the highest numbers of refugees are Ethiopia, Kenya, Chad, Uganda, and so forth. Looking at the statistics, South Africa was home to just under 70,000 refugees and just over 85,000 asylum seekers, according to recent UNHCR statistics. The main countries of origin of refugees and asylum seekers include Somalia, the DRC, Ethiopia, Bangladesh, Zimbabwe, and Burundi. If such bilateral or multilateral agreements were in place, it would be nearly impossible for asylum seekers from countries like Somalia, DRC, and Ethiopia to seek and receive asylum in South Africa, unless there was a proviso that transiting safe countries did not disqualify asylum seekers. There have been various attempts to in Africa at such arrangements, which mirrors the first safe country principle. Despite this, there is no Africa-wide protocol or agreement preventing access to asylum if one passes through a safe country and fails to lodge an asylum application there. It's very important in this context to make some very clear statements in this respect. There's no general recognized first safe country principle in international law. There is no obligation in the Refugee Convention, whether explicit or implicit, to claim asylum in the first safe country reached by a refugee. Among the minority of states that have implemented the practice through treaties and legislation, all are legally obliged to do so in a manner that protects the fundamental rights found in international refugee law. International law demands that countries provide individuals fleeing persecution with access to asylum procedures. The majority of African countries are signatory to the UN Refugee Convention, in addition to having domestic refugee protection legislation, and must give effect to this principle. Under the principle of non-refoulement, found in both international and domestic law, a state may not refuse entry or return an individual to a country where they may face persecution or a threat to their life. Countries may not simply deny entry to an asylum seeker and must consider claims individually before deciding to return an asylum seeker to a third country. Unless there is a guarantee of fair asylum procedures in transit countries that are deemed safe, denying an asylum seeker entry based on a first safe country principle constitutes indirect refoulement and is a violation of the first sending country's obligations under international law. Any African state's attempt to implement the first safe country principle has no basis in international or domestic law, lacks the procedural guarantees that apply to the practice in other countries, fails to consider claims individually before turning asylum seekers away. Asylum protection for women is crucial, especially in light of the increased numbers of women fleeing gender-based persecution and violence. The UN Refugee Convention is the primary international law framework, along with conventions like CEDAW, which help to establish a basis for protecting women seeking asylum. There are a couple of key aspects of asylum protection for women that we need to be cognizant of. The first is recognizing gender-based persecution. International and national laws increasingly acknowledge that gender-based violence, including domestic violence and sexual violence, can constitute grounds for asylum. Secondly, gender-sensitive asylum procedures are essential. Asylum processes should be tailored to the specific needs and experiences of women, recognizing the potential for gender-specific vulnerabilities and risks. And finally, protection against return. Women seeking asylum are entitled to protection against being returned to a country where they face a well-founded fear of persecution, including gender-based persecution. I'm going to do a quick overview of two particular arrangements for asylum protection that involve both the Global South and the Global North. The first is the Rwanda-UK deal from a few years ago, April 2022. The UK government said that any asylum seeker entering the UK illegally after January 2022 from a safe country such as France could be sent to Rwanda. They would have their asylum claims processed there rather than in the UK. If successful, they could be granted refugee status and allowed to remain in Rwanda. There were a lot of technicalities in this arrangement. There were several legal challenges. In November 2023, the UK Supreme Court ruled that the Rwanda scheme was unlawful. It said genuine refugees would be at risk of being returned to their home countries where they could face harm. There was a great deal of reasoning following these legal challenges, and the UK-Rwanda deal was set aside and put on the back burner. We may or may not see a resurrection of that particular deal. In 2025, Rwanda again is in the spotlight, where they are currently in discussions with the Trump administration about a possible deal to accept deported migrants from the United States. This is a developing situation, so there are very few details available at this time, but it's something to follow. Looking at current refugee flows in Africa, African women and girls seeking asylum face significant challenges, including violence, discrimination, the lack of access to essential services. They are often vulnerable due to factors like gender, race, their status as migrants or asylum seekers, and may face difficulties accessing legal protections and support. If we look at the current flows which are taking place, Malawi faces challenges currently as hundreds of Mozambicans, including women and girls, seek asylum as they flee post-election violence and political instability. Due to the close, Malawi and Mozambique share a very long border, and this is the most logical and easy place to seek safety if fleeing from Mozambique. Looking at the conflict in Sudan, this conflict broke out in April 2023. An estimated 1.2 million people had fled the country by the end of 2023, with almost all Sudanese refugees being hosted by neighboring countries. A further 9.1 million Sudanese were displaced within the country, including people displaced by previous conflict. Sudan now has the largest IDP population ever reported. Prior to the conflict, Sudan was also host to almost 1 million refugees, primarily from Eritrea, South Sudan, and Syria. Many were forced to return to their home countries prematurely or to move on to other countries. This particular group, the Rapid Support Forces, has inflicted widespread sexual violence on women and girls throughout Sudan's 2-year civil war to humiliate, assert control, and displace communities across the country. The RSF's atrocities, including rape, gang rape, sexual slavery, amount to war crimes and possibly even crimes against humanity. Moving on to SOGI-based asylum claims, multiple countries in Africa criminalize same-sex relations, and as a result, persons seeking asylum on the basis of their sexual orientation and gender identity are excluded from refugee protection on this ground. Refugees seeking asylum on the basis of sexual orientation and gender identity have no option but to seek protection in a known safe country, and there are only a handful of these countries in Africa. Looking further at barriers to women's international protection, there are multiple barriers to the protection of women seeking asylum, and this includes the various attempts of states to refuse access to asylum on practices similar to first safe country practices. In addition to this, there are a myriad of additional challenges which make access to and seeking asylum, including language, cultural barriers, patriarchal asylum systems, all that women need to overcome even before they can be forthcoming with their grounds for asylum, which could include female genital mutilation, sexual and gender-based violence, forced marriage, child marriage, forced pregnancy, and other forms of discrimination and persecution. Asylum systems need to catch up and be more sensitive to gendered persecution and need to learn how to offer more intersectional protections to women. Thank you. I'll stop there.
Thank you so much, KAAJAL, for giving such a brief but wide overview of some of the the trends on the African continent, but also some of the important obstacles that women need to overcome before they are actually even able to present the substance of their claim. And I guess this is one of the things we wanted to do, because we do spend a lot of time thinking about how women's asylum claim are being determined. But of course, with all these multi-states, interstates agreement, we see a lot of externalization and a lot of obstacles being placed in the way of actually claims being determined on their substance. But if you have any particular questions, I see that Lorraine mentions Malawi. If you have any particular questions for KAAJAL, please do put them in the chat and then we'll get to them at the end when everybody's presented. Our second speaker then is Emily WILBOURN. Emily is the program manager at Asylos, and she has a background in research relating to asylum and refugee issues. Emily will be focusing on the issue of collection and use of quality COI for safe country designations and some of the challenges that arise in obtaining COI that is relevant to women's human rights. Emily, over to you.
It's wonderful to join everyone today at the seminar. So in this part of the seminar, I'm going to take us through looking at the role of country of origin information in the application of safe states concepts, with a specific focus on the challenges that can arise in the production and assessment of COI on the situation of women in that context. So just to start from the basics, some of you may have familiarity with country of origin information already, but for those of you who don't, I've just included a brief explanation on the screen here, which is from Asylos' handbook. So country of origin information, COI for short, is an important element of the refugee status determination procedure, as it helps to evaluate whether there is a risk of persecution or serious harm if the person would be returned. COI is information on the country of origin, or in some cases, information on the country of former habitual residence or transit. We often think of COI as being produced for use in individual cases, whether that's in refugee or other types of protection claims that are being pursued. So what's the link between country of origin information and the application of safe states concepts? We'll start here. COI is integral to processes considering whether a specific country of origin can be considered generally safe or whether a country is a safe third country for the purpose of removal. There are some examples I can point to that illustrate this link. So in the EU context, for example, we see this relationship clearly codified in law. The EU Procedure Regulation 2024 indicates that safe country assessments will be based on a variety of sources which the regulation lists, and you can consult that if you're interested. The articles are there on the screen. So just last month, the European Commission published for the first time an EU-wide list of safe countries, which once approved by the EU Parliament will apply to all EU member states. And COI was an integral part of getting to produce this list. So in producing the proposed list, the European Union Agency for Asylum played a key role in compiling information from a range of sources and assessing the legal and political situations in the countries under consideration. Pointing to another example, in the UK context, the Home Office Country Policy and Information Team produces COI and advises on the development of country-specific asylum policies. And this can include assessment of the safety of a country in the context of a safe country of origin designation, or in the consideration of whether a country can be deemed a safe third country for the purpose of removal. In recent years, we've seen this in action on a number of occasions. For example, in 2024, Georgia and India were designated as safe countries of origin by the UK, with the assessment of the COI on those countries being a key factor in those developments. And in another example, the now redundant UK Rwanda plan, which actually KAAJAL has already referred to, was definitely underpinned by country of origin information, and that was produced by the UK Home Office. And it was on that basis that it determined that Rwanda was a safe country of asylum where individuals would not face a real risk of being subjected to treatment contrary to Article 3 of the European Convention on Human Rights. That was, of course, all overturned in the courts and is now redundant for reasons that we are out of the scope of this seminar. So moving on then to coming to the main theme that we'll consider throughout the rest of this presentation. If COI is to play an integral role in the assessment of the safety of states, both the quality of that COI and its fair and objective assessment are paramount concerns. But what if the COI covering the situation of women and gender-related harms was often inadequate? And what if such COI were a marginal consideration in the assessment of the safety of states? Challenges and shortcomings in the production and assessment of COI on women's and gender-related human rights issues can heighten the risk of safe state designations that overlook gender-specific forms of harm and protection risks in the countries in question. And this ultimately raises the risk that women's protection claims will be deemed inadmissible on safe country grounds, even where real risks exist. So turning to look at these challenges in a bit more detail. A primary concern relates to the difficulty in accessing information about the situation of women and gender-based harms in the first place. For example, gender-based violence more often than not takes place behind closed doors, and anyone who has undertaken research in this area will know that it's often very challenging to obtain reliable information about the nature, scale, and prevalence of such issues. Even if studies or statistics do exist, issues like cultural taboos, stigma, and lack of adequate protection and accountability mechanisms may all contribute to underreporting and mean that women's experiences are not reflected in publicly available information. Best practice in COI research states that absence of information should not automatically be interpreted as meaning that certain types of issues or violations do not exist. However, in practice, where limited or no public information exists on specific women's human rights issues, there is a risk that gender-specific harms will not be understood or accounted for in the COI research that informs safe country assessments and designations. So while the point I've just mentioned relates to information gaps or research gaps that exist in general on women, this next point that I'm going to cover relates more to the choices that researchers make about what we include within our research scope. So it's about the adequacy of coverage of women's issues in COI and human rights reports, which has been a relatively long-standing concern. For example, a 2007 guide on producing COI on women observed that evidence relating to human rights conditions in specific countries often paid insufficient attention to the experiences of women, but noted rather positively that women's human rights concerns were increasingly on the agenda. Although progress in this regard has not been straightforward. And we can see this playing out in an example that has already been mentioned and I'll come back to a few times. So an independent review of the 2022 Rwanda Country Policy and Information Notes produced as the evidential basis underpinning the UK's assessment of Rwanda as a safe third country assessed that those documents contained a lack of specific focus on the experiences of women asylum seekers within the Rwandan asylum system. Now, I should note that the Home Office refuted this point, indicating that they had included all the relevant information they could find on women. Both the UK Home Office and the independent reviewer, however, point to a general lack of information about the specific experiences of women within the asylum system in Rwanda. And the reviewer really underscored the importance of rendering those information gaps visible in making such important decisions around a state's safety. And I'll also take this opportunity to highlight an important piece of analysis by ARC Foundation. Published in 2020, ARC's report set out how, under the last Trump administration, US State Department human rights reports, which many of us know are heavily relied upon, particularly in international protection contexts, saw major alterations and reductions in the scope of women's issues covered in its reports. In particular, the reports renamed sections on reproductive rights as coercion in population control and omitted information on domestic violence, FGM, SGBV, and women's civil, economic, and social and cultural rights, amongst other issues. If media reports are anything to go by, we are likely to see similar and maybe more drastic cuts and changes to the US State Department reports once again. And this is a choice, a political choice that's being made about what should be included. As practitioners working in the field of international protection, we should all be aware of these changes and prepared to seek out alternative reliable sources. So in summary to this point, I'm trying to highlight that the failure of adequate coverage of human rights issues relating to women and gender-based harms, especially in sources that are really heavily relied upon in safe states assessments, risks women wrongly having their asylum claim considered inadmissible on safe country grounds. Aside from questions around choices in coverage, We also need to consider the quality of COI research on women, which is paramount, especially given the additional challenges we are likely to face, such as information gaps when we're carrying out research on the situation of women's human rights and gender-based harms. So awareness of and adherence to key quality criteria for country of origin information research is really important. As COI researchers, we strive to meet 5 main quality criteria, which I've set out on the screen. So relevance, reliability and balance, accuracy and currency, transparency and traceability, and neutrality. And in this next example, I'm going to point to an incident where COI research underpinning a safe country of origin designation fell short of these standards. So in considering the asylum claim of an Indian woman, the Regional Court of Brno in Czech Republic ruled against the Czech Republic's designation of India as a safe country. So in ruling against this safe country of origin designation, the regional court found that the COI file relied on by the Czech government in its designation of India as safe lacked relevant and up-to-date COI on the situation of women, including on the system of effective remedies against persecution and serious harm. So ultimately, the regional court ruled that India is not a safe country. And this case points to the importance of high-quality COI in safe states assessments. Yet I still want to point out that it's important to be aware that even where the COI initially relied upon in a safe state designation is of sufficient quality, in a context where designations are infrequently reviewed, the risk that the COI underpinning the safe country assessment becomes outdated or loses relevance or accuracy is very high. So moving on from the challenges that we may experience in the production of COI on women to another point, which is around the consideration of the evidentiary assessment of COI on women. I'd like to cover 2 examples. The first case is relating to Italy. So in March 2023, Italy added Nigeria to its list of safe states despite COI produced by the EU Agency for Asylum, which pointed to a number of security and human rights issues. A request for information about the Italian government's analysis of the safety of Nigeria revealed that the Italian government had been aware of COI, suggesting a lack of adequate protection for women, amongst other groups, yet it still went ahead with designating Nigeria as safe. Now, that has actually been overturned now. Italy has taken Nigeria off its safe states list, but that was only following a ruling by the Court of Justice of the European Union in October 2024, which ruled that if even a part of its territory fails to protect the rights of all its citizens, a state cannot be considered safe. In another example relating to the UK again, we come back to the consideration of Rwanda as a safe third country. The UK Home Office 2022 Rwanda Country Policy and Information Note on Human Rights covered concerning information regarding sexual and gender-based violence affecting refugee women in Rwanda. However, it wasn't really clear, despite the UK government publishing an equality impact assessment, how this information was assessed and what inferences were made by the UK government with regards to potential risks for women seeking asylum who could have been transferred to Rwanda under the scheme. In both of these examples, observers perceived attempts to use COI to retrospectively justify decisions that had been made ex ante on the safety of countries. A lack of clarity or transparency in exactly how states consider and weight country of origin information on women as part of the bigger picture on a country's safety raises concerns. Even in a perfect scenario where there were no challenges in gathering, producing, or accessing high-quality country of origin information on women's human rights and gender-based harms, such evidence may still appear to be given marginal consideration in concluding that states are safe. On that note, I'll leave you with some of the thoughts and questions I've posed throughout this presentation. So if COI is to play an integral role in the assessment of the safety of states, both the quality of that COI and its fair and objective assessment are paramount. But what if COI covering the situation of women in gender-related harms was often inadequate? What if such COI were a marginal concern in the assessment of the safety of a state? And even if the initial COI underpinning safe states assessments incorporated holistic and high quality information on women's human rights and gender-based harms, how do we account for changing realities on the ground in a context where it may be really challenging to successfully advocate for reassessment of the safety of a country if new information comes to light about relevant risks? So on that note, I'll bring my presentation to an end, and thank you so much for listening.
Thank you so much, Emily, for such a clear, wide presentation, really raising quite a lot of questions, a couple of which I will keep till the end. But I would leave it to that and to introduce Sonia Lenigan, our last speaker for today. Sonia Lenigan is an immigration, asylum, and public law solicitor with over 14 years of experience, and she is also the editor of the brilliant Free Movement blog. She'll be setting out the key concepts of safe countries from an international and regional legal perspective. So Sonia, over to you.
Thanks, Crystal. Okay, so I work in the UK, so that is the basis of my experience and expertise, and that is what I'm going to focus on today. Also, I have a lot of experience in LGBTQI cases in particular, so I will mention those a fair bit, but obviously women and girls are included in that group as well. And a lot of the issues, I think I'll be echoing a bit of what Emily has said, because I've got the exact same concerns as her. We work on these issues together a fair bit. So yeah, the issues and concerns that relate to LGBTQI plus cases can also be applied to women and girls generally, I think. And my overarching theme is really that the needs of particular groups, including women and girls, are often not properly considered or not considered at all when governments are devising safe country concepts. So I thought it would be useful just to look, as was said at the outset, safe country concepts is very broad. So I'm going to look at sort of 3 different ways that the UK uses the safe country concept and what the issues are in each of those areas, and how the needs of particular groups are not taken into account. So first of all, I know the previous 2 speakers have mentioned it as well, but it was a very exciting and stressful time for us all, the Rwanda Agreement. So the first safe country concept I'm going to look at is safe third country. So this was introduced in the UK, the Asylum and Immigration Treatment of Claimants, etc. Act 2004, provided for the use of a safe third country concept, meaning that a person could be removed from the UK to a country they are not a national of. Now, obviously, when the UK was still part of the EU, then that was largely removals that were happening under the Dublin regulations. So at the moment, that safe third country list has all EU member states, I think, except Croatia, as well as Norway, Iceland, and Switzerland. As Emily touched on before, there is no obligation to review the lists, and there is no appeal against the inclusion of a country on the list. Again, that's sort of an ongoing problem with the use of these lists generally. So this is where the Rwanda Agreement came into effect, as it was sending people to a third country that they had no connection to, they were not a national of. So I think this is unfortunately going to be something that does keep cropping up. As KAAJAL mentioned, the Rwanda Agreement is now seemingly resurfacing to some extent in the US, and we have also seen the Italy-Albania agreement, which is sort of changing and limping forward as the government tries to find a way to make that work. But the point is, it's really quite difficult to find a country willing to enter into such an agreement. The UK struggled a lot to find Rwanda and to sort of get that agreement up and running, sort of, even when huge amounts of money are spent. And the difficulty in getting those agreements up and running creates a real disincentive for countries to consider the needs of individual groups. So, for example, with Rwanda, there was a specific and acknowledged risk to LGBTQI+ people. And Emily also spoke about the acknowledged risk of gender-based violence in Rwanda. But those things were not enough to stop the UK from entering into the agreement, because they weren't as important as the politics of entering into that agreement. I still don't believe for a second that the UK government thought it was ever going to work. I hope they weren't that silly anyway. And then again, with Albania, we see that there are risks to people who've been trafficked in the past. So again, you know, it's very difficult to find a safe third country that is willing to enter into such an agreement that doesn't have any of these risks to particular groups. So I think this is an issue that is going to keep coming up and up as more countries try to outsource their obligations under the Refugee Convention. The next safe country concept I wanted to look at is where someone has passed through what the government deems a safe country on their journey to the UK. Now, the Illegal Migration Act 2023 proposed to make it mandatory that asylum claims would be deemed inadmissible and would not be considered where the person had passed through a safe third country on the way to the UK. Now, we are a small island, and this provision was very much designed to block most people from claiming asylum in the UK, because most people will have to do some element of traveling overland to get to us. And these provisions did indeed block people from having their asylum claims processed in the UK, and it slowed the system almost completely to a halt until we had the general election last year and those provisions were rolled back. But again, the expectation with these provisions is that people must stop in neighbouring countries and not travel onwards to the UK. And again, that just doesn't take into account the needs of different groups. And penalising people for a failure to do this fails to take into account the reality of these journeys and the reality of what people's lives can be like in these neighbouring countries. So, for example, there are reasons that single women will not want to remain in countries neighbouring Afghanistan if they've just fled Afghanistan. With Ukraine, there are reasons that LGBT people will not want to stop, for example, in Poland or Hungary. And I think this is interesting, this concept as well, because we're talking about differing levels of unpleasantness, for example. So it may not reach persecution levels, but it could be treatment that falls short of that. So, you know, to what extent would people be expected to establish persecution in these neighbouring countries before it is considered reasonable for them not to have stayed there? So these are the sort of issues that we were grappling with this safe en route country and the inadmissibility process. So that has gone away for now, but I think it's entirely possible that those proposals, or certainly something similar, could return in future, because it's rhetoric that we hear all the time. Why do they need to come to the UK? Why haven't they just stopped somewhere along the way? You know, there was somewhere safe for them to stop along the way. It's like, well, how safe does it need to be to consider it reasonable for someone to have stopped in those countries? Anyway, luckily, I can put a pin in those thoughts for now, but that is, like I said, it's something that's probably useful to keep on the back burner. The last one I'm going to talk about, which Emily has covered in detail already, which is great, is safe country of origin. And again, Illegal Migration Act 2023, Section 59 of that, the particular provisions relating to this list are not currently in force. If it is all brought into force, it essentially provides for asylum and human rights claims made by people from certain countries to be deemed inadmissible. The list includes, again, EU member states, Norway, Iceland, Switzerland, Albania has been added, and India and Georgia as well. Concerns have been raised, as detailed by Emily, including Asylos, about the inclusion of India and Georgia. In particular, Georgia, there is quite a lot of evidence that it's not a safe country for LGBTQI+ people. I do find it interesting to look at the list, and again, this highlights the problem. It is accepted that some of these countries are not safe for women, but it has been determined that they are safe for men. However, this includes countries such as Ghana and Nigeria. And so obviously there, the needs of gay and bisexual men have been completely ignored because they are absolutely not safe in those countries. As Emily mentioned, I think a big problem here is that these lists are not very fluid, and there just doesn't seem to be much of a review mechanism. So I think this is somewhere where there is a gap at the moment, and I think it would be interesting to see like a sort of COI review of all of the countries that are in this list to see who they are and are not safe for. I mean, I say this, the government has quite merrily ignored the concerns about India and Georgia being listed. But again, if we have this COI and we have this information, then it is easier to challenge decisions. So decisions made that a person's claim would be deemed inadmissible because of a safe country of origin, that is a challenge that can be brought by judicial review, not by appeal, but it can still be challenged. So COI very much has an important role to play there. The other thing that I wanted to flag about this list of safe country of origin is you go through the list, and I did this when the Illegal Migration Act was published. I think it's an interesting exercise to go through these safe lists and to see how many people from these countries the UK is actually recognising as refugees. So, for example, Albania is on the list, and the UK is recognising as refugees Albanians who have claimed asylum based on their sexual orientation, as well as women who have been trafficked are also. It's becoming increasingly difficult, but they have a decent recognition rate as refugees in the UK. And that is despite the best efforts of the government to have these claims refused. So Albanians, the fact that recognition rate is still as high as it is, I think is a real indication that that country should not be on that list. There's also Brazil is on the list, which again, I think it's one of the most dangerous countries in the world for LGBTQI+ people. So why is that on the list? And there are no disclaimers apart from the countries I mentioned where it says, safe for men, not women. There are no other carve-outs from this list of countries. There's no further explanation, which is why the use of these lists is really concerning. As KAAJAL said, it doesn't provide for individual consideration of cases, which is still important when you look through this list and you see that the UK is recognising people as refugees. And then the other countries on the list I touched on earlier are countries where you may not want to go and live, or you won't want to be in for specific reasons. Potentially, persecution is not met there, but I think it fluctuates. So, for example, Poland and Hungary have been on this list for a long period of time now, and during that period, they have gone through periods. I think it's getting a bit better now, but there have been some really serious problems with the government targeting LGBTQI+ groups, and there was never any suggestion that there would be a review to consider whether it was still appropriate that I'm looking at questions which I shouldn't be to see whether it was appropriate that those countries should remain on the list. So I think again, as highlighted by Emily, I think the use of these lists is a very live threat to asylum in the UK and also in the European context. And I think the examples of India and Georgia as sort of the most recent examples, they show how easily the concerns of specific groups are overridden and just completely ignored. And I think that this is an issue with the safe country concept generally, whereby safe doesn't mean safe for everyone. And there is just a repeatedly demonstrated unwillingness on the part of governments, generally, it seems, to acknowledge that and to take that into account. So yeah, lots of room for improvement, basically.